Squad, where justice meets hilarity. True Crime Squad, where justice meets hilarity.
500-139, State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment. I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing general.
Ms. Nestor?
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel. Pages 1 through 14 are the opening instructions that the court gave prior to opening statements.
Right.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Okay. Ms. Nestor?
You want to reread them?
No.
Oh, good.
I'll start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay. Pages 15 through 23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial beginning. Take a moment.
No objection from the state?
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little editing to remove some unneeded syntax.
Mm-hmm.
So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right?
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
From the 10th Circuit?
Right.
Yes.
State, yeah.
Garcia
Right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or their testimony about immunity, as well as for Crozier. So that all is great for argument, but I don't know that we need any special instruction, given
Okay.
that neither person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in-custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody, if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity. I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber, it should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay.
Well,
In fact,
one-
we saw
one-
an interview
yeah.
with him in custody, in
Right.
stripes.
Same with Carmen Lauber, right?
Yes.
Yeah. Okay.
And once again, this instruction is designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is There is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but,
Yeah.
That one may be closer to the facts of this case, than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah, okay. We'll come back to that. We have
Okay.
time. Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry, which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep, I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right, and then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that if that evidence that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay, I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P. 3rd 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah Appellate Court authority, defendant's objection is respectfully overruled. Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes, thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay. That brings us to page 30,
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
Do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason And when I instructed the jury in real time, the reason I gave them was motive. You weren't,
Well,
was it also go to
Can it go
preparation?
to identity, preparation,
I know it
intent?
can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice, we, argued for the admission based on motive, intent, plan, and preparation, and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's motive, plan, okay.
Yeah.
Yes, sir.
Okay. Ms. Nestor.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct, so I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it. Okay, 32, 33, 34, 35, 32 through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural, many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do. Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example. So go to page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing about a motive at all,
Right.
just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain
Right.
is a why, not a how, and why is motive.
Right, that's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that,
Because then we don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
Yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction?
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
I didn't know we pulled cohabitant.
Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of the stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Fine, it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition of attempt
Yeah,
the same as yours?
Yeah, that was added by the court before I ever
Before you
got a
did this.
chance to ask him to include it. It appears to be the same thing, so.
Okay. Just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah,
attempt?
we'll need to take a break, so put a pin in it if you want. And
It just will take me
Okay.
1 second. Okay. All right, so we can just toss this, right, Mr. Burmester? We can
Yes,
throw this out.
Yes, absolutely.
Okay.
That is-
All right. No objection to the rest of the definitions instruction, Your Honor,
Okay,
or to number 40, which comes after it.
thank you. Mr. Bremer, is there any objection to page 40?
No.
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. But I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that I think you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, that the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included or I mean, you could certainly argue to the jury some factual inference that,
Yeah.
listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
That line of reasoning or doubt.
So,
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
so I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well,
Even
here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
Imagine a healthcare provider
Right.
says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally. I think that's
there's an
still
intent to
aggravated.
commit. That's an intent to cause death,
cause
though.
the death, yep.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah,
down,
but that's
right?
a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
Yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder.
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together.
Yeah.
You know, we've split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death, intent to cause a result. That's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't in Utah because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike. Let's just go down the page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins because the court rules as a matter of law that that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
You're right, because I was going to say, I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
I mean, let's be clear. This was Melanie's idea.
Yay, Melanie.
Yeah.
Yeah.
So we're talking about the top.
So you've got
Along with A and B,
you got
right?
2 options here, right? You have the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Yeah.
Or just put a S in a parentheses, like, so it could be either?
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you. And we'll just we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here. That's fine. Okay, no, that's fine, Your Honor.
Okay. I will make similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is or homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right, 'cause
The mental state's definition on page 46.
Right, I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know, I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state to find counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions, I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So, I gotta pull the information, we gotta look at the statute. Bear with me for one moment. Melanie, I'm not ignoring you. All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76,
Here's your charging.
6, 521,
D.
2D, right?
Yes.
All right, so let's start with a couple of my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or
It's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's why.
So we'll take that out. And then, Ms. Nestor, in your submission this morning, you make reference to 2D's
Right. Let me pull that.
phrase, fees for professional services.
Right, so I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521(2)D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute. Okay. There's something going on with my computer. All right.
Excuse me.
Okay, there we go. All right, just a minute, Your Honor. 76 6 Here it is. Okay, I'm with you. Please continue.
All right, so 521(2), an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain 2 categories of things in the alternative: fees for professional services or anything of value, and then by certain means. Why doesn't it apply equally to 2 alternative categories of things?
I read that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be like, to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not what anything to do with Ms. Richins. I think they liked the second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that go, I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything, and they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product, and it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime, they got to prove it as it's written, and they just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular, because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they've proved this, and I actually think they charged the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No. I'm saying for purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's gonna just have to figure it out, but
Okay, but even in your world, in your view,
yes.
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally and knowingly or recklessly devise the scheme or artifice to obtain
Fees for professional services.
3A, fees for professional services, comma, or 3B,
But that's-
anything of
That's not how-
value.
That's not how it's written, though, Your Honor.
It's exactly how it's written. I
No, it's-
just put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take the 1, 2, and 3 out as well.
Take the, which one?
Never mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B, to make it clear, because it is an alternative, it's a list of 2.
Yeah.
It's-
I don't know how to read it any other way.
If that's wrong, it comes back, though, because that's not, these go straight to elements.
Okay. So, Mr. Burmester, any objection to including the language in the alternative form as it exists in the statute?
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
Your Honor,
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 76-6521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going back to the insurance act, that isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester?
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
On
page
count 3.
47.
I'm sorry, I gotta go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And wait a minute. Count 3. This was a different one. Let me see. I might have written it in my notes to the state. Just a moment, Your Honor. Oh, no, I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think it did. I can go back to what you emailed, or from the parties and was represented as, but it's not in the statute. neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted
Oh,
those.
I know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521(2)D would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it
I could think of one
and
right
never
now.
say anything, or
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus? What's the conduct?
By means of, and then those,
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
filing of the application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well, but yeah.
Okay, sure. Yeah. You could, yeah. You could, we could instruct the jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it,
Or-
yeah, right, yeah. We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury
Yeah.
what the state thinks and give the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay? Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection, sorry.
That's okay. So then let's look at elements of forgery, count 5, 76-6-501. 2B1. An actor commits forgery if, with purpose to defraud anyone, or with knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application, signing of Eric Richins' name allegedly to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Oh, there it is. You've got it.
So we've got to keep with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes,
Okay. But then, I think if I understand what you submitted correctly, you're asking for without the authority to do so.
right. That's right. And
Okay.
that's based, I decided the case law on that, state versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. That's an
Okay.
element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory? Or
I don't know.
it's
if we
just the
have
way it goes?
Authentication.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
Yeah, because I thought execute meant make it effective, like, I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing, or just make a
I think it's
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or the making, execution, or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it. Thank you. Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that it is 50, but this certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count 1 and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was
Yeah.
kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections?
Yeah,
Okay.
one section for each count charged. objection, Mr. Burmester?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor?
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think, I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay, did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury. I need a place to start to
Okay.
apply gentle pressure to keep working, and this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo in it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yep. Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were jurors answering it to make sure that it flows correctly.
Okay, give me just 1 second, Hunter, I'm sorry.
Your Honor, I don't, well, unless it's at the beginning. I don't think I got a copy of the verdict.
I think it was in the email that I sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now.
That is
Just
entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
let me
I
forward
can
it.
maybe just resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it.
I
Okay.
should say skip to count 2.
We're gonna take out 1B. And so this has to change to right there. Count 2. So I'm gonna take out 2B. Okay. Okay.
Concerned that other mental health.
Oh, if we include it. Yeah. Okay. So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count 2. Similar changes.
right.
Any other changes?
Yes, so I have some worries about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That would be, that takes care of my concern. Because my worry would be they would mark them both and we would never know that they were unanimous on each,
Okay.
or if they split it half and half. Does that make sense?
Yep.
Okay.
Any
No,
objection,
that's-
Mr. Burmester?
No,
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun a little. Just for flow's sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
Sure.
after that.
That's fine.
Actually, that does make more sense.
no objection from the state.
Got it?
Same on,
Remains consistent with the,
and same under
Earlier
count
question.
2 as well.
Got it. Okay. Then, before we take a break, Ms. Nestor, may I go through just what you submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins
Right.
language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's
Oh, okay.
a problem anymore.
all right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient foundation pursuant to the witness credibility instruction on page 22 to make exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that, and I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction, because O'Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuando didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
Okay.
And can I just, before you
Sure.
rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuando versus Agard. After the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Okay.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. We'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you
Okay.
get that lined up.
Okay.
But like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you. Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right. Let's, Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law. So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then let's look at the first 2 pages of the additional instructions that I sent out. Page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they,
No objection.
in place of Muji's second CR 415, which is the custody informant. Mr. Burmester.
The state objects to number 1, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
The reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant.
Draw the distinction for me. What would you see the informant as being?
I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say. They don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So And I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony, for obvious reasons.
Let me spin a hypothetical here related to the facts of this case, but not from the facts of this case, to make sure I understand your position. So it sounds like if somebody heard Kouri, or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Kouri Richins, once upon a time in 2022, in January 2022, asked me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
If we alter that just a little bit, the defendant, whoever it is, told me something, that they killed somebody, or
Right.
they shot the gun, or
Yeah.
whatever. That, I think, is different. That's not a witness to the crime. I think if the witness had said, the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position. Ms. Nestor.
We have no objection to the new informant instruction or to the making the immunity instruction just general. We're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmester is taking the position that as a matter of law, it's inappropriate to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. There are people that gave information and got a deal out of it, whether, I just have never seen that distinction made in the past, so I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests,
Travel to Nevada.
to make herself feel better because she feels guilty. All of that is not covered by, and those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask a different question? I don't understand the relationship between the first sentence and the last sentence of these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
that is the last sentence is dealing with the scenario where they find no other reason to find guilt
Right.
other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony of an informant alone. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why
All right.
that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauper's testimony alone,
No,
You'd
they
have to-
certainly can.
You'd have to add some
Right.
language to that statement.
Correct,
Okay.
absolutely,
All right.
absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay. Then, if you would please turn to page 3. This is a revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor.
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right. And then, Mr. Burmester, if you look at the 1 to 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objection, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together. All right. Bear with me for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the word, the modifier attempted to before intentionally or knowingly cause the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes, I
Okay.
believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
You know, it was supposed to be beyond. No, that is something I just need to edit to match the original. I know what you're going to say. It's going to say circumstance or circumstance is on page 5.
Also, I just caught, by looking at that, on page 4, the one before, it should say listed in element 3.
Correct. I made that.
Did you catch that?
interlineation. I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to commit this crime. This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there, get the conversation started.
So I'll let them talk first because I'm interested to hear what they say.
Other than Richins
Yeah, got it.
spelling, I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio, was
Because of the forged name?
because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my concern.
Do I have that right, Mr. Permister?
Yes, Your Honor.
Mike,
It's just
go ahead.
like frequently, when you have a forgery, there's a corresponding count, like a
Right.
theft or
Right.
theft by deception, whatever.
So the only issue I have, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry, I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
Sand coats.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you? That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So,
I mean, I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm
right.
not making a finding.
correct. So I don't understand how, if the claim on the death is based on a death that actually happened, and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or
Yeah,
not.
but I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as the beneficiary on behalf of someone. Like, I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you
And
can't
that-
forge a signature on it.
Well, if she had authority to forge, if she had authority to sign his signature.
But that's a
it's-
big if, that's in factual dispute in this case. We're just talking about legal elements here. Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, any, besides the spelling error, any,
Wait, before we go on,
Oh,
can I
I'm
just get a
sorry.
clarification? So I can argue, I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue, this may be their theory, but we don't think any of this is a crime.
you can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
I just feel like you're telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, and you tell me if there's a more artful way to do it in your
Right.
view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean, I just don't
But you don't have any burden.
know, but we are entitled to theory of defense instructions. I mean, if you're going to put their theory in, I just think adding that part on the bottom is problematic for a lot of reasons. I think just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No?
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today, so I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
Yeah, so-
whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
Absolutely. And I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head.
I
That won't be
understand.
argued. But it does help us distinguish unanimity between 3 and 4.
What-
That's the
Well,
one.
I think also the dates.
The
do that
dates are
for you.
different.
Yeah.
Absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Now, you can stipulate it to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I
Yeah.
think what he's saying is, even if the statute is somehow
Defective.
defective for not having an actus reus defined,
Right.
the evidentiary foundation and the state's closing argument will make it clear
Will cure
that
it.
they are alleging that there were multiple acts committed here.
Okay.
Is that fairly stated, Mr. Burns?
Yes. We are definitely not making the argument that somehow the instruction is improper
Right.
or
Yeah.
unlawful.
Okay. Okay. And then, anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I
we
didn't
were,
make any changes.
you left it the same. Got it.
There were no objections to count 4.
Wait, I thought count 4 was the one.
Did I miss some? I apologize.
Yeah.
Let me take a look.
Let me check. Your Honor.
I don't have any handwriting on count 4.
Just a moment. Okay, let's see. There's one. Just a sec. 2.
Mine is clean as well.
1 and 2. Just a moment, Your Honor. I'm so sorry. Count 4 was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from
That-
the statute
that had the
regarding
fees.
fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
Yep, no objections.
Okay, great. All right. I think that only, oh no, here, before we get to spoliation, Ms. Nestor, my apologies. Any, did I hand out the special verdict forms? Did I bring them with me?
And did you, the amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
back on the record, please. Counsel, we're back on the record. I've just handed you a revised version of the verdict form.
Yeah.
If you would just read through it and make sure I didn't miss anything.
No objections.
No objections.
Very good. Okay. Ms. Nestor, I have a list of practical things I need to talk about, but did you want to talk any more about spoliation sitting here today?
Yes,
Go ahead.
thank you. Your Honor, may I remain seated?
Yes.
Thank you. So the court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus, or whatever the word is, residue. I'll use an easier word.
Dust.
Residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the...
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
I don't think that
Detective O'Driscoll say that?
No, it was objected to because it was hearsay. Is my
I don't
recollection.
know whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have, they don't, like the Summit County Sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
Not that bottle, no.
Okay.
no.
Meaning no affirmative evidence, or they don't have that bottle?
They
No
don't.
affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know that the young woman, and I apologize, I cannot remember her name either, I'm just blanking right now.
Dr. Ulmer?
No, the
Ms.
lady
Gibson?
who checked in the body that
Oh.
had the tag, the red
Yeah.
tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure. So I know that she did, my recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. It's clearly it's gone because it'd have been here if it wasn't. So.
Oh, but yeah, I mean, let's come back to spoliation, right? You have to first show a violation or that a duty to preserve
Right.
existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So
Well-
who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
Well, we can do we can do affidavits as to that.
The evidentiary record for trial is closed.
No, for your evaluation purpose, it's not, I don't think your finding is based on what happened in trial.
No, but
Because all the time on
the
Tuesday-
evidence is closed. Closings are happening Monday. To the extent you were a party wanted to make an additional evidentiary showing and have the court make findings sufficient to support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, we could, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not that.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to a expert, or have it or use it at all, right? So it's missing. There's no question there's a duty to preserve it. They thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. We've just not come across that in any way. But there's definitely going to be some gross negligence here if the main container of potentially illicit drugs, of someone who was found dead of illicit drugs, is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but keep going.
Not right next to the body, there weren't. And, there was an unknown dust on the nightstand right where the pill bottle was. Could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? One option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved, and because of that, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. That may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
I understand that this is a good faith argument, but Spoliation requires findings, and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and
Right.
prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that it's material. I think the only thing that's in question is the breach, right? Like to what level of culpability was the breach? And
Or was it breached at all? I mean,
Right.
there are things such as rule-based preservation schedules
Sure,
that
sure.
absent, for example, your client certainly knew that the body was taken, right? She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm
Right.
just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. It puts us in a position where we might have to have,
And to be clear, you are not limited from making the arguments you just made to me
right.
to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Okay. Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in, but.
After you've resolved all of this, I just
Oh.
had a request.
No problem. I'm happy to hear you out in just a second. Thank you. Okay. Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So
Fine.
we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that,
Yeah.
Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind, but if he does, what is the time you want us to?
Whatever you all agree to. I just,
We'll do it.
I'm inclined to order it if you folks want it, but if you've agreed to
Yeah,
proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday. And, I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now, you can put what's in, and if you want to use some creative little thing that is just for,
Demonstrative purposes.
demonstrative purposes, the other side's not going to be able to object to that anyway, so
Understood.
we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing your on-reading instructions and closing
Sure.
arguments. And so if, Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the
Ms.
state is
Steele
present.
was here trying to talk to,
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help.
What I have, I can wait till Monday.
If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup.
Right.
Backup. So if we could just, before the exhibits go back,
Yes.
give us a few minutes to make sure we're all in agreement that that's what should go back. And then, we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that that will take longer than a few minutes and
Yeah.
will involve somebody from both sides of the beat, Brittany, after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for.
The jury does.
The
not
jury,
the
but I
defense counsel.
don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits. They're going back, correct, Mr. Burmester?
Yes.
I believe so, but I will check with that. I mean, there weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions.
Right,
For
okay, good,
example,
good. I was like, just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
a companion transcript.
We did agree to those.
Okay.
The parties did. But now I'm panicking if there was accidentally
Oh.
some big transcript that slid back past us that we didn't see.
I don't think so. Brittany
Okay.
just wanted to confirm,
Okay.
based upon the conversation we had on the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she
Right.
understood the state of affairs.
No, I
If
think-
it's been admitted
Yeah.
as an exhibit,
It
it
goes
goes to the
back.
jury.
Right.
Yeah.
I agree.
Okay. All right. Anything else today, Mr. Burmester?
No.
Ms. Nestor?
I assume, since we're doing so good and we're so far ahead of schedule, that you're not putting a timer on our closings?
No.
Okay.
Not putting a timer on the jury either.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing. We haven't lost a juror in
They are
a
a
3-week
hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They're just, they need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, afternoon, Ms. Nestel. Sure. Happy to listen.
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is, we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody can anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly, and there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep just to make sure that they get in. Our request would be that they get the 2nd and 3rd row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for the decorum order back before 0800.
So I'm just going to sound this out in real time. What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
Certainly neither
on
did
Monday.
I. Yeah.
If those rows are not filled, can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family, 2 and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richins' family and see if they need that 2nd row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an
Okay.
expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
Council, this is going to be the plan for closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richins' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind, they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, Court Security Director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for, unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of them.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? Means you got to be here, somebody from your team and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
Yeah.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else, Ms. Nestel?
No.
Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted to talk.
True Crime Squad, where justice meets hilarity. True Crime Squad, where justice meets hilarity.